The evidence essay from February of 1993 is about as typical and generic an evidence question as you're ever likely to see. The only thing that distinguishes this question from many others is it isn't really a racehorse. We are only given 4 items of evidence to discuss, and we've got plenty of time to go into reasonable depth. Take a look at the call of the question. 1. Was the question asked in paragraph 1 objectionable? 2. About paragraph 2 issues. 3. Should Reno have been permitted to read from paragraph 3? And then 4. Was the objection in paragraph 4 properly sustained? Discuss. So, it looks like evidence. It looks like 4 items. Our basic approach, relevance, objections, and then ultimate admissibility. Let's have a look at the top of the fact pattern. And we only get 1 short paragraph of facts before we get into the evidence issues. We've got a private plaintiff, Mary, suing a private defendant, Chuck Coe, for the wrongful death of Mary's husband, Hal. Hal died when a log truck driven by Boyd crossed the center line and struck Hal's car. Boyd also was severely injured and died a week later from complications. Trucco asserts that Boyd was an independent contractor hauling logs for Trucco and not a Trucco employee. Okay, stop right there. We can anticipate one of the central issues before we even read the 4 numbered paragraphs. The only reason that an employer would contend that an employee involved in an accident was an independent contractor would be to allow evidence of insurance to come in to establish ownership and control. That's the only reason that fact would be present. So we read, at the jury trial, the following occurred. 1. Plaintiff called Tom, Trucco's president, as a hostile witness. Plaintiff asked the following question. Didn't you call Mary the day after the crash, tell her it was Boyd's fault, and offer to pay Hal's funeral expenses? It looks as if we've got an admission coupled with an offer to compromise or an offer to pay some expenses, and we're going to examine those issues accordingly below. Next, in paragraph 2, numbered paragraph 2, we've got the predictable question about insurance. And it'll resolve exactly the way that we intuited above. Ownership and control can be established via insurance. 3. We've got Officer Reno taking the stand for the plaintiff. Reno testifies that Boyd had given him a statement after the crash, and he reads from his report, thus giving rise to a couple of hearsay issues. Boyd stated that he fell asleep at the wheel and ran over the center line. Finally, in number 4, Mary testifies that Hal loved her and was a kind and considerate spouse. Defendant then called Smith, a longtime neighbor of Mary and Hal, and asked about reputation evidence, and plaintiff's objection was sustained. Had Smith been allowed to testify, he would have testified that Hal had a reputation for being quarrelsome and physically violent with Mary. And you know what? I think that evidence should have come in because it goes to the value of Mary's loss of consortium claim. And no, I'm not just having another one of my regular flashbacks to being a defense lawyer. We get the call of the question again, and then a fairly straightforward outline of issues. Let's have a look at them together and see how best to organize a meaningful response to this straightforward and uncomplicated fact pattern. We've got the alleged admission and offer to pay funeral expenses. The relevance is obvious. It indicates liability on the part of the defendant. We've got a couple of different objections. The first, hearsay. The second, public policy. I conclude in favor of severance. I admit the admission. Next, we consider the insurance issue. Again, it is relevant because it attacks the defense that Boyd is an independent contractor. We have a public policy objection that is overcome to show ownership and control. Next, we turn to the police officer's testimony about Boyd's statement. Again, it's relevant because it proves liability, and the objection is double hearsay. We've got to focus on both the report and on Boyd's statement. And as you'll see, we need to go into a little bit of detail about each. It doesn't take too long, but it's a necessary step. Then, finally, we focus on the objection to Smith's testimony. I contend that the objection was improperly sustained. It's relevant because it attacks the loss of consortium claim brought by Mary. The objection would be from character evidence. I think it should be admitted over the character evidence objection. Okay, we've got a simple fact pattern for a fairly simple subject and a straightforward, simple outline of issues. Now let's have a look at the comparatively brief answer to this question that I've written and see where the action is. First, we focus on Tom's admission and offer to pay. Notice I spent a fair amount of time on relevance, and I include a brief discussion on leading questions and the fact that this was a compound question. I focus on these in relevance. One readily could have added them as objections, but I think the core objections here are hearsay and public policy, and to make it a little simpler, I put the leading and compound objections under relevance. It may seem a little counterintuitive, and if it does, do it differently. I'm just trying to cover the issues, and I want to do so in a way that makes sense. I think you'll find that the relevance section is readable and sensible. Then we get to the core of the question, hearsay and public policy. It seems as if the hearsay objection is overcome by an admission, which would be an exception in California. It would be an exclusion from hearsay under the federal rules. Next, we turn to the public policy issue. This is where we deal with the offer to pay funeral expenses. I would render this statement inadmissible based on public policy. And then, notice, I spend a sentence or two explaining the rationale of the public policy. We want to encourage parties to try to settle their differences and work out their disputes outside of court. And so we offer them a little latitude to engage in fair and open negotiations about settlement without worrying about how these statements might be used against them later. Finally, I conclude we will admit the admission as an exception or an exclusion to hearsay, and the offer to pay will be stricken on public policy grounds. Next, we turn to the liability insurance issue. I think this is as simple an issue as we will ever see on an evidence fact pattern. And it's also an issue that you've probably seen many times already in your practice for the multi-state bar exam. We focus on relevance. And it's relevant not because it goes to liability, but because it goes to the defense of Truck Co. that Boyd was an independent driver rather than an employee. I focus on public policy as the objection because usually we're going to exclude testimony about insurance in order to prevent a jury from being given an easy out. I think that it's pretty standard to expect that a jury would simply find against an insurance company or against a party that had insurance, figuring that the company's got deep pockets and thus we're able to save the individuals from grief. And as someone who has been an insurance company employee, I know that we are meticulous about keeping this evidence out. And I think that the defense in this hypothetical that we're being tested on made a big mistake in contesting the status of the driver as an independent contractor. I think the defense should have admitted he was an employee and then argued about liability. Because now this insurance issue is going to go against the defense and it's likely to hurt them in considerations on liability as well. I find the question to be permissible, and I tut-tut about the strategy of the defense. So next we move on to Reno's testimony about the statement of Boyd. It's relevant, again, because it establishes liability and essentially proves the plaintiff's case. We've got a double hearsay problem here, which is maybe the more complicated or most complicated issue in this fact pattern, and it isn't that complicated. We unpack it by examining each step of the hearsay chain separately. First, the report. The report was written in the course and scope of employment. That makes it a business record, and that would be an exception to hearsay. Plus, the report might also qualify as a past recollection recorded, which also is an exception to hearsay. Now, notice, you don't see any boilerplate in this answer. I don't spend a lot of time reciting what the rules of evidence are, and heaven forbid I would lead off with a page of boilerplate about the rules of evidence. It isn't worth point, and it takes time and distracts us from the real effort, which is analyzing the facts. But notice here how this analysis about the report really is pretty subtle and in-depth with regard to the law. I'm talking both about the obvious exception, the business records exception, and the more subtle exception, the past recollection recorded exception. Being thorough in the law in that fashion is worth an awful lot of points. A lot more points than just reciting a lot of foolish boilerplate that the corporate bar review courses foist off on you instead of giving you the straight answers about analysis. Okay, so the report is a business record, and it also is a past recollection recorded. Next we turn to the statement. The statement of Boyd is an admission, and we've already talked about admissions. They are exceptions or exclusions depending on whether we're in state or federal court. And also, I basically focus on the idea that the statement is a declaration against interest. And that also is an exception to hearsay. So I put some fairly careful thinking into framing this answer. But the actual composition of the answer is about as simple as it gets. Finally, let's focus on the fourth and final issue, the objection to Smith's testimony. And again, I contend that this is an objection that was improperly sustained. I focus on relevance, and I indicate that since Mary has sued Trucco for Hal's wrongful death, loss of consortium is an intrinsic part of that theory of liability. So the relationship between Mary and her husband would be relevant to assessing that liability. So think for a moment about famous marriages that you know about. Paul and Linda McCartney come to mind, a famous married couple who apparently spent only 1 or 2 nights apart during their entire lengthy marriage. Obviously, that relationship would have a greater loss of consortium claim than, say, the relationship between O.J. Simpson and his late ex-wife, who was allegedly the victim of spousal abuse a long time before she was murdered. So a loss of consortium claim in a violent marriage would, it seems common sense, it would be worth a lot less than a loss of consortium claim in a loving, mutually supportive marriage. So the testimony that Smith offers is relevant because it goes to the damages being claimed by the plaintiff. The objection, which was sustained improperly, was character evidence. Although we aren't told that, by inference, we're able to figure out that the objection was sustained, and the inference is character would be the basis for that. But the problem with the court's decision is that Smith's testimony is not being offered to prove that Hal acted in accord with his bad character. It isn't attacking Hal. Instead, it is attacking Mary's claim for damages, and Smith's testimony is totally legitimate. It's a good way to rebut Mary's testimony that Hal was a loving husband. So I conclude that the statement should have been admitted because the decedent's treatment of his spouse is at issue and relevant to damages. And that wraps up a consideration of a straightforward, simple evidence problem that we had to be prepared to go into in depth to answer.